Good evening, ladies and gentlemen, and welcome to this, which is unbelievably our 5th anniversary of the Lawrence Tracy debate. What a special person we lost when Lawrence died at such a young age, so suddenly, 6+ years ago. And so to this evening's contest. This evening is all about bringing into one place some of the best things from the last 5 years of this debate. In Alistair McGregor, QC, we have a proponent of our first ever Lawrence Tracy debate, and indeed of this evening's debate. Balancing out Alistair today, we have in Holly Stout a woman whose patience and good humour have been tested to the full by being led by Alistair in the past, and not found wanting. Opposing this evening's motion, one can feel the temperature of the room drop a degree or two at the mere mention of his name. We have Andrew Hockhauser, QC, from Essex Court Chambers, the employment bar's answer to the Twilight series. For in Catherine, we have a barrister whose technical brilliance is enhanced by an Antipodean ability to talk straight when all around her talk in riddles. But in Caspar Glynn, from Cloisters Chambers, we have a mortal. A vulnerable mortal. He may not be a judge, but he has the fearlessness of a gladiator and the impudence of Sid James.
Never having judged anything before, I was lucky to have met His Honour Judge Macmillan QC on the way up the stairs this evening, and I'm pleased to say he gave me a few tips on how best to do it. I shall tell you what I've told the advocates. I regard my principal function is to ensure that you're drinking and eating by 8 o'clock again. I have made up my mind.
I thought I should begin by identifying what restrictive covenants are. They are terms agreed at the start of employment, but which apply only after the termination of the contract, so as to restrict the employee's activities post-termination. The sort of restrictions that are imposed in this way can include not soliciting the clients of your former employer, restrictions on poaching the employees of your former employer, and the nasty ones, and the ones we're really interested in tonight, restrictions on competing with your former employer, either by starting a business on your own account or by taking up employment with a competitor.
This is the kind of motion that you only need to say out loud to realise that it is manifestly incorrect. Think about it, ladies and gentlemen. Restrictive covenants, a form of slavery. Servitude, a lesser but still serious form of denial of freedom, means the obligation to provide one's services imposed by the use of coercion. And forced labour means all work or service which is exacted from a person under the threat of a penalty and which is performed against the will of the person concerned. In other words, it's work for which the person has not offered himself or herself voluntarily.
Let me say how surprised I was to hear from an Antipodean the strict limits of slavery. You would have thought that someone like her, who'd been transported for a trumped-up criminal offence to one of our penal colonies, might have been more sympathetically disposed towards broadening the definition of slavery.
I had the benefit of listening, as he waved his glasses, to the 2006 debate which kicked off this series. And I heard David Smelly say that Alistair once said to him, "Solicitors don't instruct me, they just unlock the door to my cage."
Ladies and gentlemen, such covenants, even if they do not last a lifetime, clearly for their duration, infringe a person's right to work as enshrined in Article 23.1 of the UN Universal Declaration of Human Rights. That provides that everyone has the right to work and to free choice of employment. Indeed, such is the pernicious nature of these non-compete covenants that they are in fact forbidden altogether in a number of countries, most notably India and California.
The employee who agrees to restrictive covenants cannot claim to be surprised. She has entered into the employment contract voluntarily, with her eyes open. She's had the opportunity to negotiate about the nature and scope of the terms, and if she doesn't like the terms, she can walk away and reject them.
I'd like to play my joker now, please.
You have a minute, Mr. McGregor.
An employer who sets up a business, whose entrepreneurial skills generate work for many employees, is that person whose inspiration, perspiration and money have given so much benefit to the lowly and the poor, is he to be restrained from plucking the fruits of his endeavours from the trees? Is he, my lord?
Were he an artist, I would put him in the Francis Bacon school. Visceral.
Mr. Hockhauser, the joke has been played for the next minute.
Of course, restrictive covenants are a form of slavery. The whole idea of post-termination restraint is founded on the basis of getting something for nothing. And if that is not enough, many employers regard a contract of employment as the gift that carries on giving, even after the contract has come to an end. Now, as I was saying, his approach can really be summarized as follows. If the facts are against you, argue the law. If the law is against you, argue the facts. If both are against you, just argue.
To permit someone voluntarily to become a slave, he argued, is to permit them to relinquish the essence of the principle of human liberty. And international law, as set out in the Slavery Convention, follows this. It doesn't exclude those who've entered into slavery voluntarily from protection. And in any event, there will be few cases indeed where the employee really has any choice about these covenants.
And let us consider the kind of employee who is likely to have restrictive covenants in their contract. They are not only Coca-Cola employees, they are much more likely to be well-paid, savvy people who are capable of deciding what's in their own best interests. Restrictive covenants only prevent employees taking what is not lawfully theirs, in other words, the goodwill and customer base of the employer, or the confidential information and trade secrets of the employer.
And our cases since Haynes and Doman have been littered with examples of extravagant claims to confidentiality, such that in one famous case, Ocular Sciences, the judge, Sir Hugh Laddie, observed that by the time he'd got through all the claims of confidential information, he'd resolved them into a single claim, claiming that what was a true trade secret was a statement in one of the employer manuals that employees should wash their hands after using the lavatory.
Many of you in this august auditorium will have seen the film The Godfather. Many of you will remember the scene when the mob's consigliere puts a gun to the head of an individual and says, either your brains or your signature are going to be on that contract. Now, that is the picture that Mr. McGregor, a Quentin Tarantino of the bar, would sum up. Nothing could be further from the truth.
We say that restrictive covenants are a form of slavery, ladies and gentlemen, and it is time that this country caught up with Vlad's and recognised the fact.
So, ladies and gentlemen, let me finish by posing this question. If it's not slavery to put a lock on the company safe to stop employees stealing your money, why is it slavery to put restrictive covenants into a contract to stop them stealing your customers? Each is an example of the protection of the employer's property, but neither, despite what Holly has tried to persuade you, turns the employee into the property of the employer.
Why? What reason is there in all this? All this does is affect you, the public, and this is my concluding remark. You stop competition. You stop decent, hard-working, well-qualified people from setting up rival to their employers. You restrict your choice as consumers. And your choices as consumers is also a fundamental human right.
There are protections left, right, and centre. That approach is hardly resonant of the treatment of slaves, is it? Counsel contains that Phoenix had a legitimate interest in protecting itself both in regard to its clients and its products and its prices. Now, ladies and gentlemen, who was counsel urging that submission on the judge? I wonder. It was none other than Mr. McGregor QC. I gratefully adopt his submission. I urge you, when you go and vote, to bear in mind, keeping your promise, legitimate interest. There is no slavery, there is no servitude here. Vote for the right thing.